scope of Order 41, Rules 4, 22, and 33 would be the scope of discussion of today's session. And when you have Mr. S.R. Somashekhar, a retired Principal District Judge, Bengaluru, from Karnataka, you are well sure that the session would be slightly longer than the usual one, but you are also know that just like as we watched a movie on a 2D and a 3D effect, that impact is much more and people watch it more. The moment we share it on the post that we are called Mr. Somashekhar for the session, we keep on receiving messages, not only here, but also on the YouTube channel, that he's a powerhouse dynamite for the knowledge. I stop here short and I will ask Sir to take over the session. Over to you, Sir.
Yes. Good evening, Mr. Vikas Chetrat and friends. As you said, my sessions are usually longer, but today you will find that my session will be over probably in 1 hour. The reason is this. I spoke on this platform on 26/5/2024, almost 7 months back, on a topic titled Appeals from Original Decrees. I had actually forgotten that I had spoken on appeals from original decrees. Today, when I checked my notes, I found that I had spoken about it, and my notes also indicate that I have also spoken about Order 41, Rule 4, 22, and 33.
Yes.
I have titled it as only Order 41, Rules 4, 22, and 33. Proportionately, the time that I take should be less. Let me make an honest attempt in that regard.
So that will be a revision, and revisions are always better.
Yes.
Yes, sir.
Well, one may be surprised as to why 3 rules in Order 41 distance from each other by about 12 to 13 rules are taken together. In the course of my presentation, the viewers will find that though they are separate rules, each of them has a bearing on the other. First, I will take up Order 41, Rule 4, then go to Rule 33, and then come to Rule 32. For those who did not hear me on the last occasion, or those who have no exposure to the appeals at all, just 1 or 2 sentences in the beginning. An appeal is a creation of a statute. There is no question of entertaining an appeal when a statute does not provide for it. Section 9 CPC provides that all suits of a civil nature are cognizable by a civil court unless their cognizance is either expressly barred by any law or by certain provisions of the Civil Procedure Code or impliedly barred. Filing a suit in respect of a civil litigation is the right of a litigant. No authority is required. When it comes to an appeal, be it under this Code of Civil Procedure or Criminal Procedure Code or the present Bharatiya Nagarika Suraksha Sanhita or any special enactments, unless the statute provides for it, there is no question of entertaining an appeal. A statute need not necessarily provide for an appeal. A statute cannot be found fault with merely because it does not provide for an appellate remedy. Way back in 1979, Justice V.R. Krishnaiyer had an occasion to examine this. I just do not exactly remember the labor legislation that was challenged before the Supreme Court on the ground that it did not provide for an appeal against an order passed by an authority under that legislation. Justice V.R. Krishnaiyer, in his usual style, said, an appeal is only a desirable corrective, but not an indispensable imperative. An appeal is only a desirable corrective. Well, if the statute provides for it, all right. Let us exhaust it. Merely because it does not provide for it, the statute cannot be said to be constitutionally invalid or invalid for any reason. It is only a desirable corrective, but not an indispensable imperative. The second principle is though while arguing the matter or while writing judgment, we say that this is an appeal against the judgment and decree passed by the trial court, in law, as per the provisions of the Civil Procedure Code, an appeal lies against a decree, but not against a judgment. Now, when the Civil Procedure Code was amended in 1999/2002, a provision was made. If for any reason the decree is not drawn within the time allowed by CPC or by the local civil rules of practice, well, the operative portion of the judgment itself could be taken as the decree and a copy of the judgment could be produced along with the memorandum of appeal. After the decree is made ready, a copy of the decree could be filed. Section 96 and onwards, they contain outlines about the provisions regarding both appeals from original decrees and appeals from orders. Order 41 speaks about detailed procedure about appeals from original decrees. Order 43 appeals from orders. Now, usually what happens is this. There are two or more plaintiffs or two or more defendants. If it is a plaintiff, the suit is dismissed. Defendant, the suit is decreed. So plaintiffs are agreed by a decree of dismissal. Defendants are aggrieved by the fact that the suit is decreed. Normally what happens is all the plaintiffs who have lost the suit prefer an appeal. They are shown in the task title as appellants. Or all the defendants who have lost the appeal may prefer an appeal as appellants. Supposing if one of them is not intending to join the other as appellants, he or she is shown as respondent. That is the usual practice and procedure that is adopted. Perfectly fine. There should be no difficulty about it. But even if it is not done, is there any scope for that? Whether the provisions of the Civil Procedure Code provide for it. Kindly have a look at Order 41, Rule 4 CPC. Order 41, Rule 4. One of several plaintiffs or defendants may obtain reversal of whole decree where it proceeds on ground common to all. This is the marginal note to that rule. Where there are more plaintiffs or more defendants than one in a suit, that's why I said that there are two or more plaintiffs or two or more defendants, and the decree appealed from proceeds on any ground common to all the plaintiffs. I will explain what that common ground is. All the plaintiffs or all the defendants. Any one of the plaintiffs or the defendants may appeal from the whole decree, and thereupon the appellate court may reverse or vary the decree in favor of all the plaintiffs or the defendants as the case may be. A rule does not even require the leave of the court for any one of those plaintiffs or defendants to prosecute the appeal on behalf of the co-plaintiffs and the co-defendants. No application is contemplated. Neither the court can say that the appeal is bad for non-joinder of necessary parties, nor the respondent can state. But the rider is that the ground on which the suit is dismissed or decreed should be a ground common to all the plaintiffs and all the defendants. Let us say in a partition suit, a prior partition is set up by the defendants, or a will is set up by the defendants, or a plea of self-acquisition is raised by the defendants. The trial court accepts the plea of the defendants and ultimately dismisses the suit. The suit is dismissed in respect of all the plaintiffs for the same reason, that the defendants have either established a prior partition or their plea that there is a will in their favor, or that the properties are their self-acquisitions. Therefore, whether one plaintiff or two plaintiffs or all the plaintiffs prefer the appeal, it makes no difference. merely because one of them files the appeal and the appeal is allowed, uh, and we can't say that the relief should be confined only to the appellant plaintiff who has preferred the appeal. Otherwise, there will be two conflicting decrees. This is precisely the reason why Order 41 Rule 4 enables one of the plaintiffs or one of the defendants to file an appeal and prosecute the appeal. The rider is that the ground on which the suit is decreed, if it is the case of the plaintiff, or the suit is dismissed if it is the case of the defendant, is a ground common to all of them. This is the basic criteria. As I said, it does not even contemplate an application. Maybe by way of abundant caution, in the memorandum of appeal, it could be mentioned that the appellant who has filed the appeal is prosecuting this on behalf of all other plaintiffs or defendants who might have lost their suit or against whom a decree is passed. It's also not a requirement. If you still feel that such a mention could be made, there is no prohibition for making such a mention. I am quite confident that no application is required for this purpose. No leave is contemplated. CPC itself has given that leave. Now, let us go to Order 41 Rule 33 and see how it is connected with Order 41 Rule 4, removed from it by 29 rules. Power of the Court of Appeal. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be executed by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits, or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees. Provided that the appellate court shall not make any order under section 35A, that is compensatory costs, in case of frivolous or vexatious suits or frivolous or vexatious defense, in pursuance of any objection on which the court from whose decree the appeal is preferred has omitted or refused to make such order. Though the provision is too long and slightly difficult to comprehend, the substance is only this. Merely because one of them has not preferred an appeal, and when the appellate court thinks that relief has to be given to the appellant, and by granting relief only to the appellant, if there is likely to be a conflict in the decrees, that has to be avoided, and even against the non-appealing plaintiff or defendant, the relief has to be given. In fact, power under Rule 33 can be ideally exercised, particularly in partition suits. There are some illustrations. One illustration is given in the book statute itself. A claims a sum of money as due to him from X or Y, and in a suit against both obtains a decree against X. X appeals, and A and Y are respondents. The appellate court decides in favor of X. It has power to pass a decree against Y. But in reality, this doesn't happen. No plaintiff says that money is due either from the first defendant or the second defendant. He is normally sure from whom it is due. He may implicate the other person as a proper party at least, or he may say that both of them are jointly and severally liable to pay him. An extreme situation where he may say that the money is due either from X or from Y is such an event that applies. Now, from my experience on the bench, I have one or two illustrations of my own for this. The first illustration is this. I will slowly tell that. A files a suit against her brothers D1 and D2 for partition on the ground that she is also a class 1 heir. I am not bringing any joint family property, co-personary property, Vineet Sharma, Poolavati or nothing. A simple case of intestate succession under Section 8 of the Hindu Succession Act. A male Hindu has died after the coming into force of the Hindu Succession Act, that is 17/6/1956. Those who are novice and uninitiated will not get themselves confused about it. I am not referring to Section 6 of the Hindu Succession Act, nor I am referring to any co-personary property and other things. Let there be no confusion. It is a straightforward case where a male Hindu has died after the commencement of the Hindu Succession Act, 17/6/1956. There are his self-acquisitions. He has left behind intestate, that is, without leaving behind a will. That's the case of the plaintiff. She is the daughter of that intestate. She has two brothers, that is, the sons of the intestate. They are defendants 1 and 2. They admit the relationship. They don't dispute that the plaintiff is their sister. They also do not dispute that the property or properties in respect of which the suit is filed was or were the self-acquisitions of the father. There is no dispute about relationship. There is no dispute about the nature of the property. They also do not dispute the date of death, nor death itself. All these facts are admitted. What is it that the defendants have pleaded? They have said, because of a will executed by the father in their favor, in terms of which all the suit properties are bequeathed to them, plaintiff is not entitled to a share and she needs to be non-suited. That is the simple case. Though it is a little out of the scope of this subject, please have a look at Order 18, Rule 1 CPC. It says, in a situation of that kind, it is the defendant who will have a right to begin. Though normally we post the case for plaintiff's evidence, because invariably at least one of the issues would be on the plaintiff. This is a situation where there is absolutely nothing for the plaintiff to prove. We have a corresponding provision in the Indian Evidence Act, Section 103 of the Indian Evidence Act, maybe somewhere in the neighborhood of that section. We have in the Bharatiya Sashya Adhiniyama also. Well, when in law or something, the other person has a presumption in his favor, straight away he takes the burden. There is nothing for the plaintiff. The only material issue is whether the defendants prove the will that they have set up and whether the plaintiff is entitled to a decree. Straight away the case has to be posted for defendant's evidence under Order 18, Rule 1. This only aside the subject. Now, the trial court does not accept the will. That means it does not accept the case of the defendants that the father has left behind a will bequeathing the properties to them. And therefore, the trial court decrees the suit. Here, both the defendants are aggrieved, but only the first defendant prefers an appeal. The second defendant does not prefer the appeal. Though I said normally the first defendant would not take the risk of not impleading the second defendant, at least as a respondent. Well, we have seen Order 41, Rule 4. It enables him to prosecute the appeal on behalf of all the co-defendants. No need to make him a party. Now what happens? Let us see. The appellate court upholds the will. On reappreciation of evidence, which the first appellate court is certainly entitled and empowered to do, it comes to the conclusion that the will has been proved strictly in accordance with Section 68 of the Indian Evidence Act, corresponding to 65 or something of Bharatiya Sashtra Adhiniyama, it has been duly attested as required by Section 63 of the Indian Succession Act. The testator was in a sound disposing state of mind. There are absolutely no suspicious circumstances. The appellate court upholds the will. Now, what's the consequence? Having upheld the will, if the appellate court dismisses the suit, it has to say, it can't say second defendant has not preferred an appeal. I will sustain the decree passed by the second defendant. It leads to, I will uphold the decree against the second defendant granted by the trial court. It does not act. It has to set aside the decree against the second defendant also. The will is accepted. In terms of the will, both the defendants are entitled to the property. The appellate court cannot say, well, the second defendant has not preferred an appeal. I will give relief only to the first defendant. It is quite contrary, not to law. It is contrary to common sense at least. So therefore, this is one situation. I have a second illustration. This relates to a partition in respect of joint family properties. A files a suit for partition against his brothers, D1 and D2, on the ground that the suit properties are joint family properties. I have advisedly not referred to the gender of this A, because if I say daughter, several questions would arise in the context of Vineet Sharma, Poolavati and other things. I have not referred to it at all. Of course, in the first illustration, as I said, sister. Here I have only said A files a suit for partition. Yes, here, sorry. Yes, here also, yes, I have referred to as male only. Deliberately avoided a daughter here because certain questions might crop up, which is certainly outside the scope of this subject. A files a suit for partition against his brothers D1 and D2. That means plaintiff and defendants are brothers, on the ground that the suit properties are joint family properties. The first defendant says that some of the suit properties are his self-acquisitions, and so too the second defendant says that the remaining are his self-acquisitions. So the second illustration relates to a situation where a suit is filed by one brother against the other brothers for partition on the ground that the suit properties are joint family properties. Here again, the relationship is not in dispute. The first defendant says that some of the suit properties are his self-acquisitions. The second defendant says that the remaining are his self-acquisitions. Now, the trial court does not accept the contention of either the first defendant or the second defendant and decrees the suit. That means the trial court holds that all the properties are joint family properties and available for partition. Here, only the first defendant files an appeal. The second defendant does not do. This is not a case where, invoking Order 41, Rule 33, the appellate court can grant relief to the other person. Because what would be the situation? There is a decree in respect of all the properties, right? Only first defendant appeals, while the other defendant does not appeal. Here what happens is the court comes to the conclusion that some of them are certainly the self-acquisitions of the first defendant. Well, the appeal only in respect of the first defendant can be allowed, because plaintiff cannot be taken by surprise in such a situation. Therefore, this is not a case where the decree can be set aside against the second defendant also. This in brief is this. Of course, there are various other things, certain types of orders and other things which the trial court would have passed has not been passed. But such situations are rare. I have deliberately confined myself to Order 41, Rule 33 to the extent it has a bearing on Order 41, Rule 4 CPC. Today morning, I also waded through Mullah's commentary on the Civil Procedure Code. Of course, some citations, some decisions are mentioned at the footnote. Well, I will have to check the ratio found therein. A reading of those decisions and what Mullah has stated by referring to those decisions would indicate that Order 41, Rule 4 and Rule 33 will have to be read together. That's why I have chosen to discuss about Order 41, Rules 4 and 33 together. I will now, in this context, a few important decisions with regard to Order 41, Rules 4 and 33. In 2003, 9 SCC 606, 2003, 9 SCC 606, Banarsi and others versus Rampal. Banarsi and others versus Rampal. I will have an occasion in another 10 minutes to get back to this very decision when I take up Order 41, Rule 22 CPC. For the present, I am referring to this decision only to highlight the scope of Rules 4 and 33 of Order 41. 2003, Volume 9, SCC 606. I have been very slow in giving the citations. It is for you to make a note of it. Banarsi and others versus Rampal, 2003, 9 SCC 606. The relative scope of Rule 4 and 33 is explained in para 50 of this judgment. 1.5. I am reading para 1.5 at page 619 of this Banarsi Das. Banarsi, not Banarsi Das. Rule 4 seeks to achieve one of the several objects sought to be achieved by Rule 33. That's why I said Rule 4 will have to be read with Rule 33. Rule 4 seeks to achieve one of the several objects sought to be achieved by Rule 33, that is, avoiding a situation of conflict in decrees coming into existence in the same suit. The above said provisions confer power of the widest amplitude on the appellate court so as to do complete justice between the parties, something like Article 142 of the Constitution. Complete justice between the parties, and such power is unfettered by consideration of facts like what is the subject matter of the appeal, who has filed the appeal, and whether the appeal is being dismissed, allowed, or disposed of by modifying the judgment appealed against. See how beautifully Justice Lahoti has explained this scope. I will read this again. The above said provisions confer power of the widest amplitude on the appellate court so as to do complete justice between the parties, and such power is unfettered by considerations of facts like what's the subject matter of the appeal, who has filed the appeal, and whether the appeal is being dismissed, allowed, or disposed of by modifying the judgment appealed against. While dismissing an appeal, and though confirming the impugned decree, the appellate court may still direct passing of such decree or making of such order, which ought to have been passed or made by the court below, in accordance with the findings of fact and law arrived at by the court below, and which it would have done had it been conscious of the error committed by it and noticed by the appellate court. Suddenly, an illustration comes to my mind. Let us say, while describing the property in dispute in the plain schedule, there is some error with regard to the property number or extent or boundaries. The contest in the suit by the defendants is not with regard to the extent of the property or its location or its identity. The contest is on other aspects, title of the plaintiff or his own title, possession, and other things. Both the parties have gone to trial on the basis that the property in dispute is one with a particular number. This is the extent, and these are the boundaries. They have not bothered. They don't dispute the existence of the property. So the suit is either declared or dismissed or whatever it is. Now let us say the appellate court finds that from the documents produced or from the oral evidence on record, particularly the cross-examination, there is some misdescription of the property in dispute in the plain schedule. I repeat, the parties do not dispute the existence of the property. Both of them knew when the proceedings went on in the trial court as to which was the property the plaintiff was claiming, which was the property that the defendant was claiming. Nobody bothered to notice the correctness of the description. In the appellate court, that is pointed out. Even without an application under Order 6, Rule 17 CPC for amendment of the plaint, the appellate court can say appeal is dismissed, but the decree shall be read as one granted in respect of survey number so and so. Let us say 31/1 and not 31/2 as mentioned in the plain schedule. Obviously the decree will have to be drawn as though it is survey number 31/2. This usually happens in partition suits. There will be a number of properties involved. During the course of the proceeding, which culminates in a preliminary decree, the parties' focus is only on the relationship between the parties, the nature of the properties, whether it is joint family property or self-acquisition, and other aspects. They may not concentrate much on the description of the properties. They take it for granted. These are the properties available to the joint family. Ultimately, it is found by the appellate court there is some misdescription. The revenue records may disclose a particular surrender, some may disclose particular extent. Parties may find that the boundaries are something. It is open to the appellate court to say appeal is dismissed, but the decree shall indicate that the property in dispute is this and not what is mentioned in the plain schedule. This really does not call for an application under Order 6, Rule 17 CPC. It only calls for an application of mind to know the scope of Order 41, Rule 33. Then, while allowing the appeal or otherwise interfering with the decree or order appealed against, the appellate court may pass or make such further order or decree as the case would require be done, etc. The object sought to be achieved by conferment of such power of the appellate court is to avoid inconsistency, inequity, inequality in the reliefs granted to similarly placed parties and unworkable decree or order coming into existence. See the beauty of it. So to remove those inequities, inequalities, inconsistencies, and to see that the decree is workable, everything is done. Ultimately, when the commissioner goes to the spot for to give a report to the court to drop a final decree, he finds some misdescription. He finds that the survey number mentioned in the plight is something, but at the spot it is something else. Then the overriding consideration is achieving the ends of justice. Wider the power, higher the need for caution and care while exercising the power. Usually, the power under Rule 33 is exercised when the portion of the decree appealed against or portion of the decree held liable to be set aside or interfered by the appellate court is so inseparably connected with the portion not appealed against or left untouched that for the reason of the latter portion being left untouched, either injustice would result or inconsistent decrees would follow. The power is subject to at least three limitations. The court itself has identified what those limitations are. Number one, the power cannot be exercised to the prejudice or disadvantage of a person, not a party before the court. By passing some order in exercise of its power under Order 41, Rule 33, if that order is ultimately going to affect some order, some benefit given to the other party without implicating him, we can't say it. Then, the power is subject, then secondly, A claim given up or lost cannot be revived. In the trial court, the plaintiff gives up a claim or the defendant gives up a portion of the counterclaim. That cannot be revived by exercising the power under 41 Rule 33. Thirdly, such part of the decree which essentially ought to have been appealed against or objected to by a party and which that party has permitted to achieve a finality cannot be reversed to the advantage of such party. This has some bearing on Order 41 Rule 22 CPC, and as I said, I will refer to it a little later. A case where there are two reliefs spread for and one is refused while the other one is granted, and the former is not inseparably connected with or necessarily depending on the other, in an appeal against the latter, the former relief cannot be granted in favor of the respondent by the appellate court exercising power under Rule 33 of Order 41. My suggestion to the participants is please read this judgment. It's a classic not only on the scope of Order 41 Rule 33 but also Order 41 Rule 22, frequently cited. If you just read it, nothing more could remain for me to explain in this regard. There is one more decision, though reported earlier, but decided 2 days later. The one I cited is 2003 9 SCC 606, Banarsi versus Rampal, that is decided on 17/2/2023. The next judgment is dated 19/2/2023. Obviously, since it is 2 days subsequent to it, one would naturally expect 2 days, 2003. One would naturally expect that this should have a citation subsequent to 2003 9, but it is reported as 2003 3 SCC 552. Here again in paras 12 to 15, the scope of Order 41 Rules 4 and Rule 33 have been explained. Paras 12. Lastly, it is said that not all the legal representatives of the original plaintiff had preferred an appeal against the dismissal of the suit by the trial court. In accordance with Order 41 Rule 4 of the Code of Civil Procedure, the appellate court could not have varied the judgment of the trial court against the defendants at the instance of only some of the plaintiffs appealing against the decree. This was the argument, not the finding. For this, what's the answer given by the court? Para 13. This argument has no merit. That is the argument that all the persons who had suffered the decree should have preferred the appeal. This argument has no merit. In a suit for partition, plaintiff and defendants are parties of equal status. If the right of partition has been recognized and upheld by the decree, merely because only some of the plaintiffs had appealed and not all, the court was not powerless. It would invoke provisions of Order 41 Rule 4 read with Order 41 Rule 33. The object of Order 41 Rule 4 is to enable one of the parties to a suit to obtain relief in appeal where the decree appealed from proceeds on a ground common to him and others. The court in such an appeal may reverse or vary the decree in favor of all the parties who are of the same interest as of the appellate. Some other earlier decisions are also referred to in this judgment, old decisions of 69 and 71. Then, para 14, Order 41 Rule 4 enables reversal of the decree by the court in appeal at the instance of one or some of the plaintiffs appealing, and it can do so in favor of even non-appealing plaintiffs. As a necessary consequence, such reversal of the decree can be against the interest of the defendants vis-a-vis non-appealing plaintiffs. Order 41 Rule 4 has to be read with Order 41 Rule 33. Order 41 Rule 33 empowers the appellate court to do complete justice between the parties by passing such order or decree which ought to have been passed or made, although not all parties affected by the decree had appealed. Para 15. In our opinion, therefore, the appellate court, by invoking Order 41 Rule 4 read with Rule 33, would grant relief even to the non-appealing plaintiffs and make an adverse order against all the defendants and in favor of all the plaintiffs. In such a situation, it is not open to urge on behalf of the defendants that the decree of dismissal of the suit was passed by the trial court had become final. Yet another decision which could also be referred to is 2004 5 SCC 272. 2004 5 SCC 272. 2004 5 SCC 272. Bajrangalal Shivachandrai Rula. Bajrangalal Shivachandrai Rula versus Shashikantian Rula. Shashikantian Rula. This again makes a detailed reference to the provisions of Order 41, Rule 4 and 33 by referring to a good number of earlier decisions. I don't think that I need to again read them because you will find good number of earlier decisions. The other decision which I just now cited, all those things are referred to here. You may do well to read it. Yet another decision explaining the scope of Order 41, Rule 33 is AR 2007 SC 989. AR 2007 SC 989. S. Nazir Ahmad versus State Bank of Mysore. A judgment from the Karnataka High Court. AR 2007 Supreme Court 989. This also deals with the scope of Order 41 Rule 22. With regard to 41 Rule 22, I will tell you later. With regard to 41 Rule 33, it is para 8 of the judgment. We also see considerable force in the submission of the learned counsel for the appellants that the High Court has misconceived the object of Order 41 Rule 33 of the Court and has erred in invoking it for the purpose of granting the plaintiff bank a decree. This is a case where the suit filed by the plaintiff bank had been dismissed by the trial court. The plaintiff bank had come up in appeal. It was entitled to challenge all the findings rendered against it by the trial court and seek a decree as prayed for the plaintiff from the appellate court. Once it is found entitled to a decree on the basis of the reasoning of the appellate court, the suit could be decreed by reversing the appropriate findings of the trial court on which the dismissal of the suit was based. For this, no recourse to Order 41 Rule 33 is necessary. Order 41 Rule 33 enables the appellate court to pass any decree that ought to have been passed by the trial court or grant any further decree as the case may require, and the power could be exercised notwithstanding that the appeal was only against a part of the decree and could even be exercised in favor of the respondents, though the respondents might not have filed any appeal or objection. There is no need to have recourse to Order 41 Rule 33 in a case where the suit of the plaintiff has been dismissed and the plaintiff has come up in appeal claiming a decree as prayed for by him in the suit. Then it will be a question of relevant questions, question of considering the relevant questions and granting the plaintiff the relief he had sought for if he is found entitled to it. In the case on hand, there was no occasion for applying Order 41 Rule 33, etc. So these 4 or 5 decisions would tell us the scope of Order 41 Rule 33. Now, let me take up Order 41 Rule 22. This requires some explanation and full attention on the part of the participants. Order 41 Rule 22. Upon hearing, respondent may object to decree as if he had preferred a separate appeal. One thing I want to make it clear. CPC nowhere uses the word cross appeal. By usage, we are telling if there is an appeal by both the parties, there is one appeal by the plaintiff against that part of the decree which has gone against him. There is an appeal by the defendant because the entire suit is decreed, or a partly the suit is decreed, is aggrieved by that part. In respect of it, the suit is decreed. There may be 2 separate appeals. For purposes of our convenience, we say it as cross appeal or counter appeal or whatever it is. CPC does not use it. There are 2 separate appeals. They are given 2 separate numbers. They are filed by 2 separate parties. 2 independent appeals. 2 independent appeals filed by the plaintiff and by the defendant. It is also possible there are two or more plaintiffs. One plaintiff may file one appeal. The other plaintiff may file a separate appeal. So too, when there is a decree against one or few defendants, each of them may prefer a separate appeal. Usually, common arguments are heard and common judgment is passed. There is nothing in law which prevents them from filing separate appeals. If that is, if the appellant stand in the same position, it is called connected appeal. Otherwise, if the other side prefers an appeal, then it will be called a counter appeal or cross appeal. It's only the language employed by practice. CPC nowhere says it. This is very important. The word used by CPCs are cross objection. Cross objection contemplates an appeal first. Cross objection, each court may have its own rules of practice. Cross objection, whether it is separately numbered or given a number in the main appeal, they are all different. It's only a matter of procedure. Let us not get into it. To my knowledge, as far as Karnataka is concerned, at least in the first appellate courts, the cross objections are not given a separate appeal. In the same regular appeal, they are also taken on record. So, Civil Procedure Code, Order 41, Rule 22, uses the expression cross objection. It is not a cross appeal or a counter appeal. To say something as a cross appeal or a counter appeal, it should be an independent appeal. Cross objection contemplates an appeal already filed by the appellant. The respondent would prefer what is known as a cross objection. Let me read sub-rule 1, sub-rule 1 of Rule 22. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor. I'll stop there. Let me not refer to the second aspect of it, which is an enabling provision to prefer a cross objection, because it is something inserted by the 1976 amendment. I will stop here for a moment. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor. I will give you two illustrations. Suit is for recovery of money on the ground that the defendant borrowed a particular sum of money from the plaintiff. Defendant disputes that he borrowed any money. He also says that even otherwise the suit is barred by time. So, two material issues. Whether the plaintiff proves that he lent money or defendant borrowed money from him. The other issue is whether the suit is barred by time as contended by the defendant. Trial court, when it doesn't try an issue as a preliminary issue in terms of Order 40, is bound to give a finding on all issues when it does not try a particular issue as a preliminary issue. That is the requirement of Order 40. Now, the first issue is held against the plaintiff by the trial court. He has not established that he lent money to the defendant. Certainly, the finding on that issue is sufficient for the trial court to dismiss the suit. But the requirement of Order 14 is when an issue is not tried preliminarily, the trial court is bound to give a finding on other issues. The reason is this: if the appellate court does not agree with the finding of the trial court on that first issue, it will have no finding, it will not have the benefit of the finding of the trial court on the other issue. It needs to remand the matter under Order 41, Rule 23 CPC. To avoid all that, the trial courts are expected to give a finding on all issues unless only in a situation where it is tried preliminarily. Now, the trial court gives a finding in the negative against the plaintiff, saying that he has failed to establish that he advanced loan to the defendant. But at the point of limitation raised by the defendant, the trial court holds the suit is perfectly in time. Now, it is the plaintiff who is aggrieved. It is the plaintiff who is aggrieved. The decree is against the plaintiff. The suit is dismissed. It is only a finding as far as the defendant is concerned on issue number 2. That is limitation. He can't prefer an appeal. As I said in the beginning, an appeal is against a decree. The appeal doesn't lie against a finding. Therefore, here the plaintiff prefers an appeal. My suit should have been decreed as established that the defendant borrowed loan. What does it say? Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have in his favor. He will argue before the respondent will argue before the trial court, before the appellate court. Well, the trial court is perfectly right in giving a finding in the negative on issue number 1. For these reasons, the plaintiff has not established that he lent money to the defendant. Nothing prevents him from saying the issue of limitation should have also been in my favor. The appellate court cannot say you have not preferred an appeal, challenging the finding of the trial court on issue number 2 regarding limitation. Nor can the appellant lawyer say there is no cross objection, no, or separate appeal, because there is only a finding against the defendant. The suit is dismissed. Defendant is not aggrieved. He has got the relief which he wanted from the trial court. But only on one particular point, on particular issue, there is a finding against him. Therefore, he need not prefer an appeal. There is no right of appeal for him under 41 Rule 22 as it stood prior to that. So therefore, he can say, well, I don't prefer an appeal. I am not obliged to prefer an appeal. I can still canvass before the appellate court that the finding on that issue also should have it in his favor. Let us take a suit for declaration of title and injunction or possession or whatever it is. The plaintiff sets up his title on some ground. Defendant says the ground urged for title is perfectly wrong. It is false. Plaintiff is not the owner. He also says that he has perfected his title by adverse possession. An issue is raised regarding adverse possession. Trial court on that main issue regarding the plaintiff's title comes to the conclusion, for whatever reason it is, that he has failed to establish his title and dismisses the suit. But on the issue relating to adverse possession, the trial court says, no, defendant has not established the plea of adverse possession. Now the plaintiff is agreed. He prefers an appeal. Defendant can point out the finding on point number issue number 1 is perfectly right. He has not established his title. The trial court should have also given a finding. There is no counterclaim. If the defendant had set up a counterclaim seeking a declaration that he had perfected his title, certainly cross objection or an independent appeal should have been filed. Here there is only a he has not sought any counterclaim. He only attacks the case of the plaintiff on an additional ground that he has perfected his title by adverse possession. In such an event, it is not necessary for him either to file a separate appeal or a cross objection. He can urge before the trial court, before the first appellate court. The appellate court cannot say you have not preferred an appeal or you have not preferred cross objection, nor can the appellant lawyer say that he has not preferred an objection, cross objection or a separate appeal. Then what then? Against the finding in the court below in respect of any issue ought to have been in his favor, and may also take any cross objection to the decree which he could have taken by way of an appeal, provided he has filed such objection to the appellate court within 1 month from the date of service on him or his pleader of notice of the day fixed for the hearing of the appeal, or within such further time as the appellate court may see fit to believe. Now, if you have with you the Civil Procedure Code, either the hard copy of it or if it is available on your system, you will find that these words, but may also state that the finding, etc., they have all been inserted when Civil Procedure Code was amended in 1976, Act number 104 of 1976. It is here you will have to give full attention to what I am telling. Before CPC was amended in 1976, there was no way by which a defendant against a finding, same thing as far as the plaintiff also is concerned, could prefer an appeal against a finding. He could not have preferred an appeal against a finding. He could not have preferred a cross objection against a finding. Now, even now, without preferring a cross objection, he can urge before the first appellate court that the finding on that particular issue should have also been in his favor. 76 amendment says when the other side prefers an appeal, the respondent can also prefer a cross objection challenging the finding. I hope I have made myself clear. An independent appeal by his own, let us say the plaintiff for some reason does not intend to prefer an appeal at all. The suit is dismissed. For whatever reason it is, he does not choose to prefer an appeal. There is no finding, the decree is not against the defendant. Decree does not affect the defendant. He is not aggrieved by the decree of the trial court. The defendant cannot say the finding on that issue is against me. It is likely to operate as res judicata in future. No. That res judicata would apply only when he had a right of appeal. Here there is no right of appeal for him. He doesn't take the risk of filing an appeal on his own when the plaintiff does not intend to prefer. So he need not prefer an appeal. But now, when the plaintiff prefers an appeal challenging the decree of dismissal, defendant may say that finding should have been in my favor. He may also prefer a cross objection. So for a cross objection to be filed by the defendant, there must, or respondent for that matter, there should be an appeal by the appellate, the other person. The person aggrieved by a decree, not by a finding, should necessarily prefer an appeal, and in that appeal, the respondent can prefer a cross objection, challenging the finding also. But an independent appeal does not lie. This was the position prior to amendment. Even after amendment, no independent appeal, only against a finding. But an appeal is filed by the other side, the respondent may also prefer a cross objection. Then see the explanation. A respondent aggrieved by a finding of the court in the judgment on which the decree appealed against is based may, under this rule, file cross objection in respect of the decree in so far as it is based on that finding, notwithstanding that by reason of the decision of the court on any other finding which is sufficient for the decision of the suit, the decree is wholly or in part in favor of the respondent. Let me get back to those two examples. Suit is for recovery of money. Defendant disputes the law. He pleads that the suit is also barred by limitation. Trial court does not accept the case of the plaintiff that he lent money, but holds the issue of limitation in favor of the plaintiff. Here the plaintiff prefers an appeal. In the normal course, since there is only a finding against the defendant on the issue of limitation, no question of appeal. Since the plaintiff has preferred an appeal challenging the ultimate decree, it is two options. Defendant may say, relying upon the first part of Rule 22, well, I will also show to the court, appellate court, why the finding on limitation should have been in my favor. Now, since the plaintiff has preferred an appeal, he can also prefer, it's only an enabling provision. He is not bound to do it. This is the purpose of this. Here again, then how that, here it says, the limitation for preferring a cross objection is 1 month from the date of service of notice of the main appeal. So, and delay condonation is provided here itself, or within any such further time as the appellate court may see fit to allow. There is no need to make an application under Section 5 of the Limitation Act or under Order 41 Rule 3A. The power of the appellate court to extend time for preferring cross objection is also contained in Order 41 Rule 22. My suggestion to the members of the bar is, well, when the respondent prefers a cross objection, though belatedly, it will be in the interest of your own client, the appellant, to allow the appellate court liberally to condone the delay in filing the cross objection. The reason is, once for all, there will be a finality. Many times what happens is, if the case of the defendant is not properly considered, it will be very difficult for you also to convince the court, and it will be difficult for the appellate court also. Do not be technical on the ground that the cross objection is preferred belatedly. There may be various reasons for that. There may be some connected matter where something is brought up, particularly in partition suit, some other proceedings, some other property is claimed, and all that. Please don't stand on a technicality. It is in the interest of your own client to make a submission fairly to the court that the cross objection may be taken up along with the main matter. Thereby, there will be prevention of conflicting decrees. Experience has also shown that when delays are condoned, interference by the revisional court or by the appellate court is normally not there. It is only when delays are not condoned, well, the superior courts take a view. The trial court or the first appellate court should not have been too technical, because courts always allow a judgment on merit. That doesn't mean that 8 years, 10 years delay could be condoned, but I am only just putting you on top. So let me summarize the entire position with regard to 41 Rule 22. Now there is only a finding against one of the parties. Ultimate decree is in his favor. He cannot prefer an appeal. But when the aggrieved person prefers an appeal against the decree, the opposite party, who is the respondent, may also urge that the finding should have been in his favor without preferring a cross objection, or if he intends to prefer a cross objection, that is also permitted under Rule 22. This is subsequent to the 1976 amendment. Here again, those decisions which I already referred to would be of great assistance to understand the scope. Of course, I have already referred to them. One other decision, we will make a beginning from this. 1999. This is in the context of 41 Rule 22. The other decisions I said, they deal with not only Rule 22, Rule 4 and Rule 33. I said with regard to Rule 22, I will come back to you later. Rule 4 and Rule 33. Now this 1999 4 SCC 423. 1999 4 SCC 423. Superintending Engineer versus B. Subbareddy. It is from Andhra. In para 23 of this decision, the scope of Order 41 Rule 22 CPC is explained in some great detail. And para 23. From the examination of these judgments and the provisions of Section 41 of the Act, whether it's 41 of some other Act, some Bengal Moneylenders Act or something, and Order 41 Rule 22, in our view, the following principles emerge. Appeal is a substantive right. It's a creation of the statute. Right of appeal does not exist unless it is specifically conferred. This is what I said at the beginning. Cross objection is like an appeal. It has all the trappings of an appeal. It is filed in the form of memorandum, and the provisions of Rule 1 of Order 41, so far as these relate to the form and contents of the memorandum of appeal, apply to cross objection as well. Court fee is payable on cross objection like that on the memorandum of appeal. Provisions relating to appeals by an indigent person also apply to cross objection. Order 41 Rule 40, Order 44 CPC. Even where the appeal is withdrawn or is dismissed for default, cross objection may nevertheless be heard and determined. That is provided in Order 41 Rule 22(4), where in any case in which any respondent has under this rule filed a memorandum of objection, the original appeal is withdrawn or is dismissed for default, the objection so filed may nevertheless be heard and determined after such notice to the other parties as the court feels fit. Something like a counterclaim, when the suit is dismissed or withdrawn, the counterclaim has to continue. Something like this here also. The respondent, even though he has not appealed, may support the decree on any other ground, but if he wants to modify it, he has to file cross-objection to the decree, which objections he could have taken earlier by filing an appeal. Time for filing objection, etc. Cross-objection is nothing but an appeal, a cross-appeal at that. It may be that the respondent wanted to give a quietus to the whole litigation by his accepting the judgment and decree or order, even if it was for partly against his interest. When, however, the other party challenged the same by filing an appeal, the statute gave the respondent a second chance to file an appeal by way of cross-objection if he still felt aggrieved by the judgment and decree of the other. Then the next decision, as I already said, is a very enlightening decision by Justice Lahoti in Banarsi versus Rampal, 2003, 9 SCC 606. I have already referred to it while explaining to you the scope of Rules 4 and 33. Now, in the context of Rule 22, it is para 9 to 11. Now, in this judgment in para 7, there is a comparative table given. How Order 41 Rule 22 existed prior to 1976 amendment, how it is after that. Text as amended by Act 104 of 1976 with effect from 1 to 1977. Text pre-amendment. Very beautifully put. Then para 8. Sections 96 and 100 make provision for an appeal being preferred from every original decree or from every decree passed in appeal respectively. None of the provisions enumerates the person who can file an appeal. However, it is settled by a large category of decisions that to be entitled to file an appeal, the person must be one aggrieved by the decree. Unless a person is prejudicially or adversely affected by the decree, he is not entitled to file an appeal. No appeal lies against a mere finding. It is significant to note that both sections 96 and 100 provide for an appeal against a decree and not against a judgment. Next para. Any respondent, though he may not have filed an appeal from any part, may still support the decree to the extent to which it is already in his favor. Now, number of situations are contemplated where a plaintiff seeks a decree against defendant on grounds A and B grounds. In what situations cross-objection is required? In what situations cross-objection is not required? If you read para 9 of this judgment, it will be very clear to you in which situation cross-objection is absolutely required and when it is not required. Now, one thing needs to be borne in mind very clearly. Let me cite the other decisions also before I explain what I now intend to tell. The other decision regarding I have already told you the other decisions regarding the scope of Rule 22, these things only. I only wanted to highlight this points. There is one thing known as supporting a decree and attacking a decree. It is here you should be very careful. Are you as a respondent supporting the decree of the trial court or attacking the decree? If it's a question of simply supporting the decree of the trial court, no need to file a cross objection or an independent appeal. If it is attacking the decree, that means you want the decree to be set aside. Respondent must prefer either an independent appeal or a cross objection because the decree is against him. I will give one or two examples in this regard. Let us take a suit for specific performance. The trial court does not grant the decree for specific performance, but grants a decree for refund of the earnest money. What does that mean? The trial court has accepted the case of the plaintiff that the defendant executed an agreement of sale. Defendant has disputed even the execution of the agreement of sale. Of course, readiness, willingness, hardship, everything is pleaded. The trial court finds that the agreement is proved. For certain reasons, the trial court comes to the conclusion that it is not a fit case for granting the main relief of specific performance but only grants the alternative relief of refund of earnest money. This is a case where there is a decree against the defendant because defendant is directed to pay earnest money. Now the defendant does not prefer an appeal challenging the decree against him, directing him to pay refund the earnest money. Plaintiff is aggrieved by the decree to the extent that he has not been granted the main relief of specific performance. Only alternative relief he has prayed, it the court has granted. Merely because he has prayed for an alternative relief, that does not prevent the plaintiff from claiming the main relief. By way of abundant caution, keeping in view the language of section 22 of the Specific Relief Act, well, he would have prayed for the alternative relief. The Supreme Court has said, merely because the plaintiff seeks alternative relief, that does not mean that he is giving up the main relief of specific performance. Now, the trial court accepts the case of the plaintiff that the defendant executed an agreement of sale, decrees the suit for refund of earnest money. Here there is a decree against the defendant. There is also a decree against the plaintiff because decree is one of dismissal in so far as the relief of specific performance is concerned. Defendant does not choose to prefer an appeal, directing him to refund the earnest money. Only plaintiff prefers an appeal, refusing the main relief of specific performance. In this case or in this situation, the defendant cannot say, invoking the first part of Order 41 Rule 22, that the finding regarding that prayer, that release, that issue, whether the plaintiff is entitled to specific performance, entitled to refund of earnest money, should have also been in his favor. Here it is not a case of supporting the decree. He supports the decree only insofar as the refusal of the trial court to grant the relief of specific performance, but he has to attack the decree insofar as the refund of earnest money is concerned. For attacking the decree, mere relying on the first part of Order 41/2022 will not help the respondent. He has to prefer either an independent appeal or a cross objection. He can't say, well, let the plaintiff file an appeal challenging the decree of the trial court which has refused specific performance. Then I will also tell the appellate court that decree for specific refund of earnest money, because there is a finding against him that the agreement is proved. It is not just a finding. There is also a decree against him for refund of earnest money. To get that decree of refund of earnest money set aside, he has to point out to the appellate court that the finding regarding execution of agreement of sale is incorrect. That he cannot do without preferring a cross objection or a cross appeal. I am conscious of the fact that the audience before me is not just confined to Karnataka, but we have a judgment of the Karnataka High Court in this regard, beautifully explaining this position in respect of a suit for specific performance. This is ILR 2009 Karnataka 4527. ILR 2009 Karnataka 4527. Dhayalan, Dhayalan, Dhayalan versus Muniswamy. ILR 2009 Karnataka 4527. Well, this Banarsi, which I said, has been referred to. Good number of earlier decisions have been referred to. The concept of attacking the decree and supporting the decree has also been explained in this case. So this is another aspect of the matter which the participants will keep in view. So let me make it clear. Prior to the amendment of CPC 1976, there was no scope for this. Against a mere finding, the respondent could not have preferred an appeal. Even now, he is not bound to do it. He can only show to the appellate court that the findings would have been in his favor. But there is an enabling provision enabling him to prefer a cross objection also. But he cannot prefer an independent appeal in the appeal filed by the appellant by way of a cross objection that can be done. The limitation for preferring cross objection is 30 days from the date on which the respondent receives notice of the main appeal. And the court can extend it. No application under Rule 3A or Section 5 of the Limitation Act is required. The provision itself contemplates, and the courts have also taken the view that condoning the scope of condonation under that 41 Rule 22 is somewhat different from the scope of Section 5 or Order 41 Rule 3A. As I gave you a bit of advice, it is better to allow the appellate court to condone the delay and take the cross objection on record. If for any reason the main appeal is dismissed for non-prosecution or withdrawn, the cross objection can continue. So when it comes to the question of support in the decree, no need to prefer a cross objection. But when the defendant or the respondent wants the decree against him set aside, he can't simply rely upon the main part of Rule 22 and say, I am content with it. He has to challenge it because there is a decree operating against him. Therefore, having regard to these provisions and the decisions which we have referred to, I am sure you will find that rules 4, 22 and 33 have some common thread. Ultimately, the object of these rules is to see that the litigation comes to an end once for all and there is no further scope. This is the position in law. And though it's slightly outside the topic that I have chosen for myself, one thing with regard to Order 41, Rule 5. When the suit is dismissed, there is absolutely no decree to be executed. I have in my experience seen that even when the suit is dismissed, application is filed under Order 41, Rule 5 CPC by the plaintiff appellant. That cannot be done. Supposing if he finds that, let us say, it is a suit for declaration and injunction or mere injunction, where the suit is dismissed, if it is the opinion that taking advantage of the fact that the suit is dismissed, defendant is interfering, well, it will be open to him to file an application under 39 Rules 1 and 2 CPC in the appellate court. For heaven's sake, don't make an application under 41 Rule 5 CPC when the suit is dismissed, when there is absolutely no executable decree. There are other requirements under 41 Rule 5. A case of substantial injury is to be made out. Not that usual averment, the very purpose of the appeal would be defeated. That would not satisfy the requirements of Order 41 Rule 5. It is a different matter that the courts are liberal and granting stay. But if the court looks into the provisions of Order 41 Rule 5, the appellant will be in a suit. Therefore, kindly see that the averments you make in the affidavit in support of the application for stay under Order 41 Rule 5 strictly conform to the requirements of Order 41 Rule 5. And conditions also will have to be imposed because experience would have shown that when once the stay is granted, the appellant may not turn up at all. So it should be limited at a point of time. Stay till the next state of hearing or something. Maybe for genuine reason that stay could be extended and the appeal could be taken up on merits. Of course, this is totally aside the subject, but since unusually I have closed the session probably in 1 hour, I thought that I should also speak to you about Order 41 Rule 5. Well, I have nothing more to say. If there are any questions, I have deliberately avoided the judgments of the Karnataka High Court except one with regard to that specific performance suit. Other things I have spoken. Well, if there are any questions connected with this, I am prepared to answer.
There's only one question, sir. It says,
Yes,
that's in
please.
the chat box.
Yes, please.
Suppose suit of plaintiff is decreed,
Uh.
but on one issue, the findings are against the plaintiff. The defendant does not file any appeal, and is there any remedy for the plaintiff to set aside those findings which are against him if it does not affect on future litigation between the parties?
Suit of the plaintiff is decreed, but on one issue, the findings are against the plaintiff. The defendant does not file any appeal. There is no question of the defendant filing an appeal because the finding is only, is there any remedy for the plaintiff to set aside those findings which are against him? If not, its effect on future litigation between the parties. Now, suit is decreed. He is not aggrieved by the decree of the trial court. There is a finding on a particular issue. He cannot prefer an appeal against a finding only. Therefore, when he had no right of appeal, when he had no opportunity to file an appeal, when there was no requirement for him to file an appeal, that finding, in my opinion, certainly does not affect his case in future litigation. There is no question of res judicata because for res judicata to apply, there must be a concluded finding. He had no opportunity to challenge that because the defendant also doesn't come up in appeal. If the defendant had come up in appeal, plaintiff respondent under 41 Rule 22 could have contended that the finding should have been in his favor.
Yes. So before we part, we can, since we have some time, we can discuss upon Order 41 Rule 5.
Yes, I have said it. So there is no question of.
It is in. There's another question. In multiple plaintiffs' case, if only one plaintiff prefers appeal, can the other plaintiffs who didn't prefer appeal be arrayed as respondents in the appeal, though the plaintiffs have common interest?
Yes, that could be done. That could be done.
Yeah. So thank you, sir, for sharing your knowledge.
And just only one thing.
Yes,
when
sir.
a common judgment is passed, two separate appeals are required. Two separate appeals. Sometimes what happens is connected matters. They are clubbed. Common evidence is recorded, or at least a common judgment is written. So technically, there are two suits, two decrees. So the two separate appeals will have to be preferred.
Even in the writ petition, they do the same way, different LPS.
Yes, that is the position.
Yes. Thank you, sir, for sharing your knowledge. It sparked off the old memories because it has the lot of overlapping, but a lot of people have watched it today again on the YouTube. As they say, that knowledge keeps on improving the more you read and more you practice. Thank you, and thank you to Kaushik and his wife for
helping me.
No, helping everyone. So they have a larger interest to pay back to the society. Yes, sir. Thank you.